Today we'll talk about factors that come into play when closing a civil case, a personal injury case, a tort case. As I had discussed in prior blogs, the issue of expenses is important for the would-be client to discuss with his or her attorney at the outset. And it's important to know what is the attorney's policy regarding reimbursement of expenses. Does the attorney expect the expenses to be paid by the client as they are incurred? Or does the attorney expect the client to reimburse him at the conclusion of the case, regardless of the case's success? I've answered that for my firm's policy, and the policy, just to quickly reiterate, is that we do not ask the clients to provide money as expenses are incurred, and nor do we ask for reimbursement of expenses in the unlikely event that a case is not successful. But in the vast majority of cases, thankfully, they are successful. So at that point, your attorney, and my office's policy, of course, is to go through our books, have the bookkeeper present a list of expenses, and we can discuss those expenses with you and explain why they were necessary in the pursuit of your personal injury case. We also provide actual invoices, and certainly would provide them upon request as well. Now, the expenses come out of the client share, and the fee as well comes out of the client share, and it's a contingent fee, as I said, so there are no hourly costs. There's nothing times this or that. It's really typically divided by 3 for the fee, and then the expenses are, as I say, reimbursed in the successful case. But increasingly in recent years, and much to the dismay of lawyers, we have to deal with medical liens. Now, those liens can arise from a variety of sources. Most people today have health insurance, so it will be their health insurer who is asserting a claim for reimbursement for what they paid out when there is what is called a third-party recovery. And medical liens have been very difficult to deal with because they can eat a significant share of the client's case. However, there are 2 things that you should bear in mind. Number 1, these can be negotiated, and there are very good methods in negotiating those liens down. And then secondly, I don't consider the next thing getting the lien holder to take less than they expected, because there's an argument that if the lien pertains to treatment other than for which the client got reimbursed, that shouldn't even be part of the lien. Let me give you an example. In a case where a client sustains a few different injuries, could be a herniated disc in the neck, it could be a shoulder injury. If the third-party insurer says the shoulder was not related and essentially refuses to pay money towards that, what I have done is, if I've settled the case for a handsome amount, I will turn to the lien holder and say nothing that was paid for the shoulder should be reimbursed to you, lien holder, because we didn't get anything for that from the third party. I mean, if that has been the third party's position, the third party insurer's position, get a letter from them and have them carry some water for you and explain to the lien holder that those sums were not factored in, and that injury was not factored in the settlement. So that could actually be quite advantageous, even though at the time of the mediation, for example, you're not happy to hear that there's a contest on the applicability of the shoulder injury. You could turn it into something of an advantage. Now, there are other debts that could be on a case. That one could arise from a workers' compensation lien. There could be something that's increasingly a source of concern now called Medicare set-asides. And going back to the workers' comp situation, you have to figure what's called the Hunter set-off. Those are very technical things, these set-asides and workers' comp liens. They have to be dealt with and should be dealt with by somebody who is experienced and competent. And finally, and we'll visit this in a in the next blog, or at least in a blog, the issue of structured settlements, payouts over time, something that may be appropriate for certain clients. And that certainly is something that is discussed at the time a release is signed. But hopefully I've covered some of the major issues that you will see and confront when you are about to receive the money in the settlement of your personal injury claim. Thank you.